Let me just start off by saying that as an attorney who represents a number of school districts throughout the state of New Jersey, I spend days at seminars on this issue in and of itself, a single issue. We can spend an entire day with a room full of lawyers and discuss the HIB legislation and still come out with unanswered questions. So it's going to be very difficult for me to give you a short, concise, do it by the numbers analysis and review of the legislation and its application, because it's still in its infancy. This law has only been in effect as currently constituted for 2 years. It started in the 11-12 school year, so this is now the third school year in which this legislation has been enacted. There are regulations that are still not yet promulgated by the Commissioner of Education to further explain the legislative intent of the statute. And certainly it doesn't really change that much, something that not only school districts but everyone always knew was a concern. And obviously the legislation was enacted because of data that was collected about bullying and harassment that was being conducted on school premises, not only at public schools, but certainly even in secondary schools and private schools, colleges, etc. So that's what was the initiative for this kind of legislation. But I want to make sure that there's two things that we understand throughout this entire discussion. And the first is, as I said, it's not that much different than what was on the books before what came to the law. Obviously, we have affirmative action laws that try to prevent hostile work environments, not just from employees, but hostile educational environments for students. So that affirmative action complaint procedure that had always been in effect throughout school districts was always there and continues to be there as a mechanism to avoid hostile work environment situations, sexual harassment situations, again, not just from an employment or an employee standpoint, but also from a student's standpoint. The second thing I wanted to make sure that everybody understands, and this is the mantra, that whenever we talk about this, I want you to always have it in the back of your head, because I might say something and it's not going to make any sense, and how could this possibly be the resolution to a certain situation? But the mantra is always in the back of your mind that we've always had a code of conduct that says what's right and what's wrong. And if you do something that's wrong, you will be penalized or punished or disciplined as a student in the district. That was here before anyone ever put the 3 letters together to make a HIB. And it will continue to be there now and after that legislation was put into place. And you could have a violation of the code of conduct, but not have a HIB violation. But therefore the consequences, that even if it was found to be a HIB, might be exactly the same. The consequences, the discipline, the remediation, the counseling, the behavior modifications, all those kinds of things that we're looking to do as educators and as people who we want to teach the students right from wrong and teach them a lesson as to how to do better in the future. All of those mechanisms were here before, and they're still here. It's just we've added another layer in order to ensure that we have the right answers and the right procedures to address those concerns. That's really what we're talking about from a global standpoint. Again, with regard to trying to limit this as much as possible from a time standpoint, I think the best way to proceed with this would be to go through basically, and I did already more or less, the legislation about the time it's been in effect. There are very few, if any, cases that have been litigated to a level of the Superior Court or the Appellate Division of the Supreme Court of New Jersey under this legislation as currently enacted. So we're not going to be able to talk too much about the law as a judge has interpreted it, because again, as I told you, it's only 2 years old under the way it currently is, under its current enactment. So I'm not going to be able to cite you cases or give you a good perspective as to precedent, as to how a judge is going to review some of these findings. So from the legislative standpoint, I think we've really covered that. What I also want to cover, though, is the most important elements of this HIB legislation deals with, goes to the definitions themselves, because we throw those words around, HIB, and harassment, intimidation, bullying, but there are specific definitions, as any statute should have, in telling you what that means, so that we are able to interpret it, not just from a legal perspective, but from the school district's perspective, from the administration and the board, to figure out whether it applies or it doesn't apply. So I will go through with you rather quickly, and you can see why you can spend days talking about this when I go through the statute with you with regard to the actual definitions. The third part of it that I want to go through real quickly is the procedure, because there are procedure with regard to reporting, there's procedures with regard to the investigation, there are timelines with regard to those investigations, there's an appeal process, and all of those I think we can cover rather quickly on a rather easy timeline. And the last are the practical applications and the unanswered questions that you will obviously see are here when I give you a quick review of those first few items that I want to go through with you. So, with regard to the legislations, to go back, there were these laws in effect, these HIB laws that were in effect back to 2002, but they weren't in the format that we see them today. And you got and from 2002 until 2011, they were just out there without any regulations to speak of, other than telling you that you should adhere to the statute, which really doesn't help anyone. And the governor and the legislature also were trying to get together to develop a better HIB statute that would be more workable. And they did that, as I said, effective for the 11-12 school year. You have to also keep in mind that when the legislation was adopted and put into place, without regulations, because regulations are there to help us interpret the law and to apply the law and to fill in the gaps, because as thorough as legislation is, it's never, because lawyers can make things, I guess, say a lot of different things in a lot of different ways, and so can private citizens when they take a look at it. You need these regulations to give the intent. We don't have those. So I'm going to stick with the definitions for you. And I think the best definition is the easiest one that we are going to have to look at, but I want to read it very slow the first time, and then we're going to go back and break it down into segments. Because they actually define, by the way, the statute reference is 18A 37-14, are where these definitions for the current harassment, intimidation, and bullying statutes are located. 18A, as most of you know, 18A is the statute that school laws falls under. Now there's three parts of this definition that's important. The first part to define is, who can a victim be? And there's no question that the victims are students in these cases. Not like an affirmative action where I was talking about victims could be employees, or victims could be co-workers between other people. When we're dealing with the HIB, the victim is a student. An employee could not be subject to a violation of HIB under this statute. Only the students could be victims of HIB under this statute. The second definition, obviously, is who can the perpetrators be? Who are the potential bad guys, or girls, or students in this particular legislation? And really, it could be just about anybody. It could be another student. It could be a staff member. It could be another employee in the district. It could be a contractor to the district. It could be the board attorney. But again, it has to be to the student. So anyone who comes in contact with the students on school grounds, at school activities, through the internet to one of our students, those people could be the potential perpetrators of this statute. And the third definition is the incident itself, the definition of what a harassment, intimidation, and bullying actually is. And let me go through it with you. I'm going to read it one time and then we're going to go back and break it up. That's what lawyers do. Harassment, I'm reading straight from the statute. Harassment, intimidation, or bullying means any gesture, any written, verbal, or physical act, or any electronic communication, whether it be a single incident or a series of incidents, that is reasonably perceived as being motivated either by any actual or perceived characteristic, such as are the characteristics: race, color, religion, ancestry, national origin, gender, sexual orientation, gender identity and expression, or a mental, physical, or sensory disability, or, and this is the one we're going to talk about at length about, or by any other distinguishing characteristic. All the other ones I think we can figure out, but we'll go back and make sure that there's no uncertainty as to those. But the interesting one, and the one that's causing the most misconception, and the one that's causing the most misinterpretation as to whether there's a HIB or not, as to did it occur to the victim based upon the victim's other distinguishing characteristic. By the way, that definition still is not done yet, so I'm going to keep reading. Any other distinguishing characteristic that takes place on school property, at any school-sponsored function, on a school bus, or off school grounds, as provided in another statute for discipline, that substantially disrupts or interferes with the orderly operation of the school or the rights of other students. That's the definition. Now, that's a lot of stuff to deal with to determine whether there's a HIB or not a HIB. The two easy ones we took care of. Students could be the only victims, and just about anybody who deals with our students could be a perpetrator. So that's clear. Now the question is, was it a HIB or wasn't it a HIB? And that's when we have to go back to this definition, because there are certainly events that happen on a day-to-day basis in schools, depending upon the age of the students, depending upon the circumstances that led up to an incident, that will make the district reach a determination, a conclusion, that either the HIB existed or it didn't exist, because it really comes down to the intent of the perpetrator and the reasonable impression upon the victim. And those two things sometimes aren't the same, because the perpetrator may have meant to do something for a specific reason, but the victim didn't perceive it that way. And that's why if we go back, all these words that I just was using in describing it come from the statute itself. Go back. Gestures, written or verbal physical acts, pretty easy. Any electronic communication, we all are starting to find out more and more what those mean, and every day they change as to how they can be done. Whether it be a single incident or a series of incidents, so again, based on the severity of a single incident, it could take just one incident for it to happen, or in the common definition that we all know about harassing. Harassing usually we think is something that happens over and over again, but that could be the series of incidents that we were, minor incidents that are a series would be equivalent to a single serious incident. And again, the key to the entire definition is as follows. That's reasonably perceived as being motivated. Now, reasonably perceived is by the victim, reasonably, which means we get a whole room full of people, and if 99 of those people wouldn't have perceived it to be a problem, but one person does, it may not necessarily, notice I didn't say it isn't, it may not necessarily be a HIB just because the victim perceived it to be, because if a reasonable person wouldn't have perceived it to be that way, it shouldn't meet that definition. Now, again, you can see how we can not only spend days talking about this, but I have no doubt in my mind, it's been a long time since I went to law school, but I have no doubt that Rutgers University can spend a whole semester just talking about this one paragraph without any regulations to define what they mean, to have a discussion as to how we're going to interpret this one paragraph of that statute. So let's continue. Perceived as being motivated either by any actual or perceived characteristic. That means it doesn't even have to be a real characteristic. It doesn't have to be because of race or religion or ancestry. It could just be a perceived characteristic. So if I thought you were one of those characteristics, and I did it because I thought you were one of those characteristics, I, as the victim, I, as the perpetrator, could still be found guilty of a HIB violation, even if you're not possessing one of those characteristics, only if I perceived it, and you reasonably perceived to receive it. So it works both ways, and that's why I said sometimes they may not mesh. You may perceive it, but a reasonable person wouldn't perceive it. And even though I thought that you had that characteristic, you may not have, but if a reasonable person would be upset about it or concerned about it, I could be guilty as the perpetrator over that. Everybody following this? I think I'm pretty good. So I think I'm explaining it pretty good. All right, good. And now let's go to the characteristics, such as race we know, color we know, religion we know, ancestry we know, national origin we know, gender we know, sexual orientation we know. Gender identity and expression is one of the new ones that we're all not very clear to know as well, but I think we understand that it doesn't necessarily have to be sexual orientation. It could be just your gender identity or expression, cross-dressing, people who believe that they are the other sex. That characteristic would be a protected characteristic under the statute without going any further. Mental, physical, or sensory disability, obviously we understand those aspects of people who may have disabilities in the school. And here's the one that I said we would spend the most talking about, or any other distinguishing characteristic. I'm open for suggestions as to what people think that means, and again, no clear direction as to what that really means. Now, the problem and the confusion and the misconception all lies in that, because we all pretty much understand that if someone is harassed or bullied or intimidated because of the other characteristics, we know what those characteristics are or what they were to be perceived to have been. It's this other distinguishing characteristic. And the discussions that we have throughout these seminars that the school legal community is attending goes, how do we define those better? Is it tall people versus short people? Is it heavy people versus skinny people? Is it weak people versus strong people? Or is it popular people versus not popular people? All of these kinds of classes of students that we could possibly find in a community like this or a community anywhere across the state would have all of these different classes or groups of students that could fall under distinguishing characteristics. And there is no definitive answer as to what that really means. And the best way that I can explain it is the way that it was explained when the Supreme Court of the United States talked about obscenity. And the definition of obscenity by the Chief Justice was, you know it when you see it. So these other characteristics, we'll know it when we see it. There may be some that one district might perceive or define differently than another district might define it, based upon, again, the age of the students, the circumstances surrounding it. We're pretty much going to get an idea of whether it was because there was something about that student, that caused some other student or group of students to do what they did. And if they did it because of the kind of student that pupil is, then it would probably meet that definition because they did it because of something, some characteristic, some reason that the way they looked or the way they sounded or the way they spoke or the way they held themselves out, that would be the definition of this other distinguishing characteristic. Now, here's where the people get confused, and rightfully so, because of this kind of definition that just sits out there. we hear it all the time, that it wasn't the person, it was just a conflict between kids. Kids would be kids, and it's really not harassment and intimidation and bullying because it was merely just a disagreement or a fight between kids. That's true. There is a difference between normal conflict between adolescents or even older students or younger students and doing it because of the distinguishing characteristic. And again, the best way for me to try to explain it is, if it is targeted, there's this conflict because of this particular person and something that this particular person has, and we go out of our way to do it to that particular person, I think you could probably fall under that definition of other characteristic, because you could probably find something that is distinguishing that person from everybody else, because that's why the perpetrator chose that victim. However, if it's random, if it just happens because someone is in the wrong place at the wrong time, that victim was not the victim because they were targeted, because of their distinguishing characteristic, whatever that really means, but they just happened to be the kid fourth in line that wound up getting into the confrontation with some other kid, rather than the fifth person in line, just because it just happened, it was random. It was a conflict that wasn't based on anything other than the randomness of it. And I think that if we use that in the back of our mind, we're good. And remember the mantra. Lawyers might argue and come up with this great theory that it wasn't based on the characteristic, it was simply conflict, and it's not a HIB because it was random. Remember the mantra. That doesn't mean that what that kid did is not going to go unpunished, it's not going to go undisciplined, and it's not going to go without remediation because it violates the code of conduct, again, depending on what they did. And if they did something that we're considering, is it a HIB or isn't it a HIB, they probably did something serious enough that it probably will fall under the code of conduct anyway. So we don't have to worry that these lawyers decided that this definition doesn't meet HIB, it's not a distinguishing characteristic, and therefore nothing's going to happen. Well, no, it doesn't mean nothing's going to happen, it just means it might not be a HIB under the law, because we got the mantra. All right? So that's the definition, and again, we're not done with the definition, but the rest of it becomes easy if we can distinguish between the characteristic and the conflict or the randomness of the problem. Remember, it has to take place on school property, or it has to take place at a school-sponsored function, or on a school bus, or off school grounds, that substantially disrupts or interferes. So again, now we're going to how severe it is. Just because a kid says something to somebody, depending on what is said, it might not substantially disrupt or interfere with the orderly operation of the school. It's gone. 5-year-olds say something to another 5-year-old. 5 minutes later, they don't even remember it anymore. So it's not going to substantially disrupt or interfere with the school operation. So it might not fall under this definition, even if it was a really bad word. Again, because it has to meet this statutory definition based on the circumstances. Older students have longer memories. Older students don't forget. Older students might want to retaliate. When there's retaliation based upon what was said, that might substantially disrupt or interfere with the orderly operation of the school. We got a problem as the district, and we got to deal with it. And it certainly meets the statutory definition. And if it doesn't, but it's still something serious, we got the mantra. So that's the definition of the harassment, intimidation, and bullying. Now there are subparts to that definition that I can go through with you rather quickly, but for purposes of time I wasn't keeping any, and I know I can go on for a while. I will let you know that real quickly those other 3 criteria that are in that definition is a reasonable person should know under the circumstances will have the effect of physically or emotionally harming a student or damaging the student's property or placing the student in reasonable fear of physical or emotional harm to his person or damage to his property. Well, that's what we talked about. Okay? So we understand it's got to be the reasonableness standard of the victim and the perception or actual characteristics in the mind of the perpetrator. Has the effect of insulting or demeaning any student or groups of students. Again, going to the characteristic and what is actually said and how hurtful something like that would be. Creates a hostile educational environment for students by interfering with the student's education or by severely or pervasively causing physical or emotional harm to the student. There's this legal theory that's called the eggshell skull theory. And everyone says, what does that mean? Eggshell skull theory, that means you pick on a victim that has a soft skull, and you only hit them with a pencil and you crash their skull. You took your victim, and you're liable for that, hitting a victim in the skull with a pencil, and that could do the same damage to a hard-headed guy like me, where you're going to take a hammer and the damage won't occur. The pencil caused, well, eggshell skull theory to mean that you are responsible for hurting their skull even though you only used a pencil and you didn't think it was going to hurt that much. But if you cause the same damage as it did with the hammer on me, the damage is the same. And you can't use the excuse, well, it was only a pencil. And that's really what that deals with, that the victim might really be upset about this. And again, we got to go back to the reasonable victim and how a reasonable person would perceive it. But as to the harm and to the real damage, the physical damage or emotional damage that's done, is real whether it was a pencil or a hammer. You take your victim the way you find them, eggshells. Probably very antiquated, but I'm not sure even law school tells you that anymore. But that was always the analogy that we always had. So that's the definition. Procedure is always something that people also get confused on with regard to how this process is supposed to start. And I'd like to run through that real quick with everybody, because the procedures deal with reporting, notification, what you're responsible for, what you're not responsible for, what we as a district can or can't tell the parents of the victims, the parents of the perpetrators, the parents of the witnesses. The district, just using this as an overall reminder for everyone, we're dealing with students who have confidentiality rights, and one parent doesn't have the right to know about another student's activity in the school, because we have federal laws under FERPA, and we have state laws that follow FERPA that protect those students from having other people know about them except for their own parents and the district administration, the district staff, etc., on a need-to-know basis. So that still applies under these rather unique investigatory provisions and procedures, but those always have to be followed. And that's why a lot of times parents are going to say, I have a right to know about this. Well, they don't have a right to know about it. And the reason for that are the FERPA laws that I was referring to before, that the district won't be able to necessarily tell you, even though your child was a victim, what did we do to the perpetrator? And the statute doesn't give us that right to tell them things other than what the statute tells us we're permitted to tell, even the parents of the victim. So let's go to the reporting. When somebody, anybody, board member, administrator, employee of the district, visitor, guest in the building, sees or perceives that there is, and they have to go through their statute, they're probably going to stand there and go, the perceived, they're going to have to notify. If you see something that's not right, they have an obligation to notify the principal of the building that they believe a HIB occurred. It's an obligation that you have to report it. By the way, if you report it and it turns out not to be, you can rest assured the statute gives you immunity from being sued about that if you report it and it turns out it wasn't the case. So obviously you should err on the side of caution, like they tell us to do at the airports and on the subways. You see something, say something, because it's better to say something than not to say something. And if it turns out that it was nothing, don't worry about being accused of falsely prosecuting or accusing someone of doing something. Timelines are very, very quick, and timelines have to be followed under this statute as compared to when we were talking about affirmative action complaints, things in the past, the old HIB legislation. These time constraints were not as rigid and as quick, and they are rapid fire. As I said, immediately. You're supposed to tell somebody immediately, the same day. Within 2 days, you have to submit it in writing. So in other words, I assume you tell somebody verbally first, they're going to tell you, you need to put it in writing, because we're not going to do an investigation merely on a verbal allegation. So if a student is complaining against another student, a student is complaining against a staff member, the victim needs, or the victim's parents need to put in writing, or the board member who sees it in the building needs to put in writing within 2 days of them seeing that, so that it's sent to the principal and the investigation can start. The investigation must start 1 day after they receive the written notification. Must start 1 day after. So if you think about it, an incident starts on day 1. The latest that the incident can be filed in writing is day 3. And that investigation has to start by day 4, after the incident first was reported or occurred. Now, the investigation is then conducted in a 10-day period. There are specialists that are specifically trained and assigned to the buildings, and it's not the principal. In each district and in each building should have a specialist that will be able to conduct this investigation. Certainly they can use the assistance and the resources of the building administration. Certainly they can use the assistance of the board attorney if so requested by the superintendent to do so. But it's the specialist that conducts this investigation, that interviews people, that figures out whether or not that statutory definition that we were talking about, A, has been violated, and B, if it has been violated, is there a recommendation for a type of penalty. They have 10 days to do that. Now, that report has to be submitted to the superintendent from the specialist once it is completed, and it has to be filed within 2 days to the superintendent. Superintendent then takes it, reviews it, makes a determination as to whether they're going to find, again, if there was a HIB violation, and if so, what the appropriate penalties would be, what kind of remediation would take place. And again, remember the mantra. It could very well be, no HIB took place, but there's still going to be a code of conduct violation based on the investigation that was conducted, and therefore remediation and discipline would take place, because even though it wasn't a HIB under the definition of that statute, it still violates the code of conduct, and we still should remediate that problem. Then what happens is the superintendent, at the next board meeting, after they receive the report, the superintendent has to give that report to the Board of Education. Now, the board then gets the report, and I did skip a step. The parents of the victim and the parents of the perpetrator would get a notification from the administration that the investigation has been completed. That's when we're going to get into this situation where people think they're going to get all this information as to what happened. No, they're not. The parents of the victim and the parents of the perpetrators are only going to get what the statute requires us to give them, because we have to protect the FERPA rights of both students, both the perpetrator and the victim, if we're talking about a student kind of conflict issue here. So what they need to know, and what they're supposed to be provided with, is the nature of the investigation, that basically there was a HIB investigation conducted. Second, whether a HIB was found, meaning that we find that it reached the definition and violated the definition of the HIB that I went through. And whether discipline was imposed or services were provided. You notice the statute doesn't say what they were, just whether discipline was imposed or services were provided. So the parent of the victim is only going to get that information. They're not going to get to know what happened to the other student, but they're going to know that there was a HIB finding, or the contrary, there was no HIB finding. But that's the only information they're entitled to at that point in time. Obviously the perpetrator parents would get a letter that is more detailed, because they need to know what the consequences were to their own child, what the discipline was to their own child, but they're entitled to that information. The victim's parents are not. Then what happens? Either side is not happy with the result, they have the right to appeal it to the board. The board then has an obligation to review it. Most circumstances, the board gives the opportunity for the side that is unhappy with the determination to come before the board and make a presentation. It's not a hearing, it's not a trial, there's no swearing in of witnesses. It's merely a presentation to explain to the board why they believe that the administration and the specialist did not do a thorough enough, complete enough job, or they reached the wrong conclusion in this case, whether it was a finding or not a finding of him, depending on which side is seeking that appeal. The board then has to make a determination on that appeal by its next board meeting. Obviously, the board would contact the appealing parties to tell them whether it was affirmed, meaning that we agreed with what the superintendent had done in this case, whether it was overturned or rejected as to what the administration did, or whether it was modified in some way. And that would be the only three options under the statute that is provided for the board during its review of appeal by a dissatisfied person that appeals it under those circumstances. That's not the end of the process, because just because the board says it, everything's appealable. The parent or the victim or the employee, whoever it is who was not satisfied with the board's determination, has two other options at that point. They can appeal the board's decision to the Commissioner of Education, and they have to file that appeal within 90 days, just like any petition of appeal would be filed to the Commissioner of Education, 90 days from the board's decision. Or they have 180 days to file a complaint with the Division of Civil Rights. Basically because, as you saw from the definition, in most cases, unless we're dealing with that funny distinguishing characteristic definition that no one's really clear what it is, the other definitions, if there was a claim that there was a HIB, it could fall under the Division of Civil Rights jurisdiction for a violation of those other characteristics that people would claim was a violation of their civil rights. So they have 180 days to actually file that complaint after the board's determination. That's the procedure. That's where most times we run into a lot of problems from a communication standpoint, because people don't understand the FERPA implications. They don't understand the time constraints we are under. One other point, because this is the one thing that I always forget to talk about, and I did here too. When I talked about the 10 days that the specialist needs to complete the investigation, there is a provision in the statute that says that in the event new information comes up after the 10-day period, the specialist has the ability to amend or supplement their report. Because that just makes sense. If you're making things have to happen within 10 days, and depending on how many people you have to talk to, or people who are not available, or something just doesn't work out. The problem in the system and the problem in the statute is it still requires you to submit the report within the 10 days. But it gives you the opportunity to supplement it if other things come up after that. It makes sense on the one hand, but it makes absolutely no sense to give them the 10-day limitation on the other hand, because what's the point? But at least it's there, so I don't want people to think that we're there with a stopwatch, and once the 10 days is up, there's no way that additional valuable, relevant, important information comes up that we can't hear it. Well, of course you can, if the specialist so believes so. But again, it goes back to the specialist making that kind of determination. So that's the procedure and the notification. Where does that leave us? Where does that mean we should be going? All districts are dealing with the same situation, and the concerns and the problems that we have is how do we deal with these practical applications and these everyday, these day-to-day situations that happen when you're dealing with students. Kids will be kids, and that's why they're called kids. They don't act like adults. Sometimes some adults don't act like adults either, but for the most part, kids act like kids, and that's when the specialist and the administration, and then if it gets to the board level, those are the kind of determinations and decisions you need to make. Was it kids acting like kids? Was it just that situation that should be resolved? And one other footnote, I don't think there's anything that precludes a easy, amicable resolution to a problem, just like there is in your affirmative action procedures and investigations that people are all used to dealing with. And there is this, again, remember I told you the first day, there's the verbal notification, and there's the verbal discussion with the principal that something may have happened. There's nothing that says that that matter in and of itself, even if it would have risen to a level of a hit, but it wasn't that serious an issue, doesn't preclude the administration, principal level, from resolving it. Making sure that the victim and the perpetrator, again, two little 5-year-olds, having a problem, doesn't mean if that can be resolved with parent notification and discussion and resolution, that's what we're striving to do here. Now, again, based on what the circumstances are, but it doesn't mean that every time that someone claims that there's a hit, that we've got to go through all these steps. You got to do this legal analysis through that definition, because most times they probably could be resolved at a very low level on an informal basis, making sure that it's resolved. Most cases should be like that. If they can't be, then we've got to go through this process. And the statute doesn't preclude that kind of resolution, and that's probably why they gave that period of time between the you must notify immediately and then you have 2 days to submit it in writing, because hopefully it will be resolved before it gets to writing, because remember, the investigation doesn't start until it's in writing. So if it can be resolved before it gets to a written stage, it certainly should be, in most cases. And if it can't be because either the perpetrator doesn't agree, or the victim doesn't agree, or the parents don't agree, well then we have to go to the step where it's a written complaint, investigation takes place, and all the procedures are followed. So from a practical standpoint, I want everyone to understand that this doesn't mean that every time two kindergartners start to call each other names that they don't even know what the names mean on the playground, that we've got to go through this entire legal exercise, because hopefully they could be resolved through the conflict. Again, it could very well be, though, that the victim and the parents of the victim are very hurt by what was said. They meet the definition, they want to proceed, and then we have to follow those procedures. But hopefully there could be a resolution short of this involved process. Unanswered questions? Plenty, as you can see. I'm sure you've all sat here listening to me talk for quite a long time. But I certainly could answer some of your questions, and I think the best way of answering those questions will be once we get those regulations, which were due last December, but as we know, sometimes the wheels of Trenton move a lot slower than the wheels of justice, so they're not getting up to those regulations yet. I certainly would want to answer any questions. I don't want to keep you much longer, but I think that overview, I think, tries to give everybody an idea as to how this is supposed to be applied and why there is a lot of misconception and confusion over the statute.
I have a quick question. If a parent comes in with a student who they say has been harassed, intimidated, or bullied, is the administration allowed to voice their opinion as to whether it meets the criteria? Are they allowed to guide them in any way or suggest anything?
I think that they certainly could do that. They don't make a determination, certainly, because, again, if someone believes that it was a violation and they want to go and put it in writing, then we've got an obligation to investigate it further. But in that day period that I was referring to before, there's supposed to be some kind of mediation process that takes place in order to alleviate having to go through this exercise, because it is involved and it is serious. And I was going to start off with a joke, but this is not a joking thing. I was making a presentation, we'll start with a joke. Well, this is serious, and it should be taken seriously. And again, depending on the specifics of the incident that is alleged by one side. Again, just because someone alleges something happened doesn't mean it even happened. And so just because someone says it happened, we don't have to make a conclusion that it did. That's why the investigation takes place. And that's why we're charged with doing those kind of things. Because at the point of the allegation, it is just that. I mean, we can produce a video to show that it happened. Well, that just means it happened. And now we've got to see whether it's a hit. But answering your question, I think it's necessary to try to mediate the problem if it can be mediated on a lower level, as it should be.
situation. What happens though if that situation in isolation can be mediated, however, it's the same conflict that keeps arising between the two children?
Then again, under that definition, it becomes that harassing definition, because it's not just a single incident, but it's a continuous concern. And I would think at that point in time, both the administration and the victim's parents would say, we can't mediate this any longer. It's got to be dealt with from a HIP perspective, because it's continuous. It's not just a single incident any longer, and now it's meeting the definition, and we want this to proceed from both the victim's perspective and from the administration's perspective.
Yes, thanks, Michael. It's very thorough and understandable.
But it was for some.
Yes.
As I said, it's still confusing to a lot of lawyers.
Just a couple of questions. One has to do with the training and qualifications of the person who is,
Specialists.
who is the specialist. Is there specific training that that person in district must attend?
Yes,
Okay, and that's run by the state?
yes.
Okay.
There's professional development that's provided to the specialists to get their qualifications for them.
Okay. And another question has to do with the remediation. Is there HIB-specific remediation
Actually, there is.
dictated by the
Actually, there is
statute?
a list, and if we were going to spend a few hours talking about this, I actually have the list of those recommended remedial steps.
It's in our policy.
I'm sorry?
Is it?
Our policy.
It should be set forth, it's supposed to be set forth in the policy.
Okay.
And I do have your policy here, and that's why I have them. Bear with me 1 second. I have this up. Where's the last page? Here it is. For example, in your policy, there is factors for determining consequences, factors for determining remedial measures, examples of consequences and remedial measures, examples of consequences and examples of remedial measures, such as factors for determining remedial measures, life skill deficiencies, social relationships, strengths, talents, traits, interests, hobbies, etc. Examples of remedial measures is peer support groups, restitution, recommendations of student behavior, corrective instruction on relevant learning experiences, supportive student interventions, behavioral assessments modifications, behavioral management plans, assignment of leadership responsibilities, involvement of school disciplinarian, student counseling, parent conferences, alternative placements, student therapy, student treatment, suspensions, expulsions. I mean, there's obviously the end of the other end of the spectrum, but those are just a partial list of those kind of things that we have. And it's in your policy.
Anybody else have any questions? I have 2 quick questions, Michael.
Sure.
The first was is with procedurally. You had made mention to the fact that the Board of Ed gets a copy of the report after the superintendent. Are we to get a full copy with the details, or just the fact that a report was issued?
Now, the report is not detailed.
Right.
If you remember, the report, the different reports, the specialist report to the superintendent is a detailed report.
Right.
The report that goes to the victim and the perpetrator's parents is a very perfunctory report. The board certainly has the right, as the reviewer, to request or be provided any information with regard to the full investigation, because you basically are the ultimate determining body from the district level with regard to that. So certainly the board should, if so charged to do so, be provided with all the documentation in order to make a well-informed decision.
And then the second issue is with regard to the FERPA laws. It seems to me that there must exist conflicts during an investigation, trying to maintain privacy and still do your due diligence with regard to an investigation. Is there any guidance with regard to that in statute?
There isn't, and again, that's one of the major questions that are still unanswered as to how you walk that fine line. But again, it's really no different whether it's whether it is a HIB investigation or an investigation that we do because it's, you know, two kids who had a conflict and we're trying to deal with the resolution. You know, you can always go back to the old days. Kid throws spitball at teacher. Teacher doesn't really see because the teacher's back to the kid. Kid gets thrown down to the principal's office and the kid then says, I didn't do it. You need to investigate. So what do? We talk to the other students. Did you see Johnny throw the spitball or not? Now, that's violating all these FERPA rights because they're talking to other students. Now, we notify the parents first that we're going to talk to their students. But not to take it out of a HIB situation, it's the same kind of investigation. You've got to talk to the students. You contact the parents. Parents will know the identity, certainly, of the alleged victim. In this case, it would have been the teacher, but let's say it was another student. So those violations, those don't violate FERPA per se, because obviously when you're talking to potential witnesses or victims or potential perpetrators or witnesses, they have to know the players in order to fairly give you the answer. The FERPA concern really lies more with the discipline that's meted out to a perpetrator, that what other parents aren't permitted to know. Facts of what happened, again, everyone knows that Johnny and Jimmy and Janie are all in the class together, so the identity of those students is not violating FERPA to the other students or the parents of those students, because they all know they're in the same school, the same building with each other, the same classroom with each other. Once you start to tell them something about something in Jimmy's file, and you're Janie's parent, that's when we get into a FERPA problem.
Understood.
If that answers your question.
It does. Does anybody else have anything? Thank you very much, Michael. Certainly informative,
Good to see
comprehensive.
all you.